And for more, I'm joined by the Federal Justice Minister and Attorney General, David Lametti. Thanks for making the time tonight, Minister.
It's a pleasure. Thank you.
Now, the Canadian government became a full supporter of the UN Declaration 7 years ago. Parliament passed the UN Declaration Act 2 years ago, and today you're now unveiling more than 180 measures across nearly 30 different departments and agencies. So what's the timeline for this phase of the process?
Well, this is obviously a longer timeline. We had, according to the legislation that we passed 2 years ago to the day, we had 2 years to co-develop an action plan with Indigenous leadership. We've done that. Those are the 180 measures, 181 measures. We've gone back and forth over the past 2 years. Various departments, various ministers and ministries with the varieties of Indigenous leadership across Canada. Great deal of back and forth. Now, obviously, the timeline is longer. What we really have is nothing less than a roadmap for reconciliation. Some of the measures will be able to be implemented more quickly. Others are going to take time. But the point is that we are either going to consult, cooperate, or co-develop, depending on the measure. There will be certain things that we're going to co-develop with Indigenous peoples. That will take more time. There are other cases where we've added an obligation to consult or an obligation to cooperate. And again, these are priorities that were identified by Indigenous peoples themselves.
So then on that list of the 181 measures, how much of these are new measures versus policies and plans that the government has already had in place over recent years?
A fair number of them are new and significant. For example, the UN Declaration requires us to have an accountability mechanism that is Indigenous-led. That's something that has never been a part of government policy or platform before. It now is. It became that as a result of the Declaration. And so that's now, again, there's a process that we have committed ourselves to co-develop that, to develop and co-develop that institution, and it will be Indigenous-led. So that's something that is new. There are a number of new things. A number of them, I guess the best way to put it is we've committed ourselves to a process to walk a path together without necessarily dictating the outcome. That's colonialism. Colonialism is dictating outcomes. We're engaging in a path with Indigenous peoples. Finally, it should have been 150 or 200 years ago. We're engaging to walk a path with them and to develop the outcomes together.
Now, I do want to ask about measure number 1 in that list, which is making federal law consistent with the Declaration. What is that process now going to look like?
Well, it's number 1 for a reason. It's in Article 5 of the UN Declaration. It's Article 1 in the Action Plan. Every law that we pass has to be in conformity with the UN Declaration. I have recently tabled in the House of Commons, in the Senate, a bill that creates a universal non-derogation clause with respect to the rights that are protected under Section 35 of the Constitution. So a treaty and inherent rights that Indigenous peoples have. This will be, this article in the action plan is in addition to that. We are now going to have to make sure that the kinds of processes and substantive standards that exist in the Declaration also become one of the benchmarks for us as we develop law in this country and as we envisage evolving processes for the passing of those laws. So this will take more time, but this is fundamental. It is more than just a simple check-off. Is this law in conformity with the principles of the UN Declaration? There's also an obligation, I think, to, as I said, walk the path with Indigenous peoples.
Okay, and I want to just go a bit deeper then on what the relationship is going to be between the government and Indigenous people as this process moves forward. Because in April, as you know, the Assembly of First Nations, they wanted an overhaul after you released the draft plan because they said, for one thing, the consultation process was inadequate, and you even acknowledged to the Special Chiefs Assembly that it wasn't a perfect draft plan. So how have you been addressing those AFN concerns over the past 2 months?
By working hard. The portfolio holder for the AFN, Regional Chief Terry Teegee from British Columbia, will be with us at the announcement today. He and his team have done a lot of work with us over the last 2 months. Roughly 80 provisions were added to the action plan in that 2-month period. There's been a great deal of back and forth with not only AFN Regional Chief Teegee, but also other leaders within the First Nations community, as well as other Inuit and Métis leaders and leadership groups. So we always said that first draft was a draft, that there would be things missing, and it would instigate a flurry of activity. It did. The plan's not perfect. It can't be perfect, but it is pretty good. It is a good roadmap moving forward. Like with any map, we will course correct as we have to. There are procedures there, formal and informal, for reviewing the plan, but also the plan will evolve as we implement it. And if we see gaps, if we see other ideas that come up, we will move and course correct. And I think Indigenous leadership across this country has understood that we're partners now, and we will walk together.
Okay, in the past few years, there's been some provincial pushback to implementing the declaration. Have you made any progress with those governments on a path forward and on their concerns?
Well, this act only applies to federal laws, and certainly we looked at the example of British Columbia, which has passed its own legislation implementing UNDRIP and has its own action plan as well. So we were very much inspired by what happened in BC. We've tried to keep the other provinces informed, the other provinces and territories, of what we're doing. We're hoping that this will create a virtuous circle of people participating, implementing UNDRIP at the provincial and territorial level. But even if that doesn't happen yet, there hopefully will be a taking into account, if you will, of UNDRIP by provincial legislatures, territorial legislatures, simply because it exists at the federal level. So we're hoping the principles of UNDRIP will inspire from the get-go, even if it isn't necessarily the case that a province or territory has formally adopted UNDRIP.
Okay, and just to close with a more specific question on that point about the provinces, at that last AFN Assembly, you did discuss potential changes to those 1930 resource transfer agreements with the prairie provinces. Are they part of this implementation plan?
No, I was answering a question. There was a great deal of frustration in the room because a number of provinces hadn't really engaged with Indigenous interlocutors with respect to those questions. I didn't make a commitment at that time. I just acknowledged the frustration, and I think that is something that provinces will have to discuss with Indigenous peoples moving forward.
Okay, Justice Minister David Lametti, I want to thank you again for your time on this.
Thank you.